Okay, good morning, Mr. Sharp. We are
Good
back
morning,
here
Julie.
again. Last time we spoke, we were talking about the test case that the FCA was bringing to deal with the whole issue of the insurers' response to the COVID-19 pandemic. So the FCA are bringing this test case on behalf of policyholders. What broadly are the coverage issues to be decided, and what will the case decide?
Well, Julie, what the case is, in terms of coverage, what the case is going to, in essence, look at is the following. It's looking at representative wordings from 91 distinct policies. Now, there are various permutations between these policies in terms of wording, but they're all going to be considered. In very broad terms, the FCA is standing in the shoes of all policy holders. So it's saying, right, I am a policy holder, I have a business interruption insurance policy, I want to recover under it. That's the FCA's, that's what they're doing. I am the policy holder. And what the case is going to broadly decide is, in relation to certain non-damage covers, of which obviously notifiable disease is, as opposed to a flood, which clearly is physical damage, and in particular notifiable disease and denial of access cover, should this give rise to a business interruption claim? That's the first point. The second point is that in relation to all of the advice, instructions and regulations given by the UK government, should they be considered together as the authority action and should not be considered when looking at the question of causation? Thirdly, where there is no express exclusion for pandemics in a policy wording, no exclusion should apply. So if your policy is silent as to whether it's got pandemic cover, then they are saying that case it should be covered. It wasn't excluded, it should be covered. And where the policy refers to a vicinity to trigger cover, so this is the policies where if there is an outbreak of a notifiable disease within a 25-mile radius, and also the one that says a occurrence of the notifiable disease within the premises, so people's buildings, what the FCA states are that COVID-19 can be found in all areas of the UK, and that the policy wordings do not limit cover to loss caused by disease or other trigger, only where it occurred within the relevant proximity. As the FCA say, and I've referred to the learned opinion of counsel, his view is you can't compartmentalise a virus. A virus is everywhere. It doesn't operate in watertight containers.
Yeah.
If it wasn't everywhere, the government wouldn't have made the orders it did to lock us all down. It would have locked down specific parts of the country. It would have locked down perhaps certain sections of society. I don't know, but it wouldn't. But it didn't because it's everywhere. And it knew it was everywhere. So that's what that's what it's going to do. Those are, the broad coverage issues. In terms of what the test case will decide, well, the result of the test case will be legally binding on the insurers that are parties to the test case in respect to the interpretation of the representative sample of policy wordings considered by the court. It will also provide persuasive guidance for the interpretation of similar policy wordings and claims that can be taken into account in other court cases, including Scotland and Northern Ireland, by the Financial Ombudsman Service and the FCA in looking at whether insurers are handling claims fairly.
Right.
The test case is not intended to encompass all possible disputes. To be fair, it couldn't possibly. But to resolve some key contractual uncertainties and causation issues, to provide clarity for policyholders and insurers. It will not determine, though, and this is going to be a problem, how much is payable under individual policies, but will provide a basis for so doing.
Ooh.
Now, that's broadly what causation issues are going to be looked at, and that is what the aim of these cases is. It's to provide some clarity, to provide some certainty, and hopefully then insurers will go, okay. Now, to be fair to insurers, they're in an uncertain position as well. They need to know what their exposure is.
Mm-hmm.
Now, this case will hopefully identify those policies that respond, in which case insurers can say, okay, we can now start working on how much we think those claims are going to be, and release some of the reserves that they may have been holding in relation to COVID-19 claims. So it provides clarity from both sides. That's its aim. That's why there has been a good deal of cooperation between the FCA and insurers, because to some extent, a limited extent at least, we need to get this resolved. We need to know where we are standing in relation to this.
Yeah, everything's on hold.
Yeah.
Okay, last time you said you had a concern about the lack of consultation with policyholders and brokers by the FCA. Has this changed?
It certainly has. They obviously didn't listen to me. I'm quite sure they didn't. But I was a bit concerned that, is there sort of, are they in this together a little bit with the insurers? But plainly they're not. The FCA will put forward policyholders' arguments to their best advantage with using a highly experienced counsel team, including Colin Edelman QC, Leanne Malaki QC, Richard Coleman QC, and the solicitors they've got are Herbert Smith Freehills, who are no slouches when it comes to insurance. The intended action will not prevent policyholders from pursuing issues through negotiated settlement, arbitration, court proceedings as a private party, or taking eligible complaints to the Financial Ombudsman Service.
Mm-hmm.
So there may well be, after this case decided, people saying, well, no, that's still not right, I'm going to take my own action. But hopefully, those will now be far less than they would have been before. They've made sure that policyholders and insurers intermediaries are properly engaged throughout the test case process. I found out yesterday that 2 consumer groups who are acting on behalf of aggrieved policyholders are now going to be allowed to make some submissions to the court. Now, they may be in written form, but they will be able to say, and this is what I was concerned about, look, we thought we got business interruption cover. This is what's happened to our business as a result of us not getting any business interruption cover. So, court, this is a serious matter. And I was concerned that that wasn't getting across. I'm far less concerned now. The FCA have gone so far as to, on their website, have a policyholder engagement bit where a policyholder can submit a statement to the FCA, pointing out what effect it's had on its business, etc. The FCA are at pains to say that they're treating that as confidential. And they're also consulting with policyholders and intermediaries, i.e. brokers, at key stages in the test case. Now, to be fair to the FCA, if you want to find out more information, they have got a very, very good section on their website. If you go into the FCA, basically website, and just type business interruption insurance, it is all there. There is a good update from the FCA as to exactly where we are. And they've even gone so far, very unusually, to put the pleadings on their website as well. So their statement of case, I've read their statement of case. There is no, they have gone for it. They have rejected every single argument that insurers have put forward in relation to why they're not paying. So they really are going for them.
Right.
Insurers obviously have defended their case particularly well, but there is now getting a little bit of panic going on here because one insurance company has said it wasn't our wording, it was the wording of the broker. See, what sometimes happens is that a broker will come up with a new area of coverage and will draft a policy wording saying, look, Mr. Underwriter, we'd like to offer this to our insureds. Will you underwrite it? The wording's then passed to the insurer, who considers the wordings, and will come back with comments. He may say, no, we're not going to write that. Sorry, I'm not doing that. Or they might come back and say, well, actually, yes, we will write that, but not subject to that clause, etc. The broker then markets the policy, people take it up, and the insured then writes it. And as a matter of law, the contract is between the policyholder and the insurer. But one insurer is saying, well, no, that wasn't our wording, that was invented by a very large broker, and really, we didn't mean to write it. So there's a bit of scrabbling around for position going on already. So it will be very, very interesting, this case. But my concerns about the FCA in some ways not putting policyholders' case forward strongly enough, I take that back. They really have. They are really doing the best they can. So there we are. So I'm looking forward to the outcome. So there we go.
Excellent. The old we didn't read it properly defence. That should be interesting. I look forward to that one. Lastly, where are we in respect of the timetable for all of this? When are we likely to get some finality?
Well, I'm very pleased to report that there genuinely has. It does show what you can do if you get the parties cooperating in terms of not taking minor points, not taking procedural points, but just the aim is let's get this sorted out.
Yeah.
The FCA started their court case by issuing a claim form on the 9th of June. On the 16th of June, there was a case management conference where effectively a judge gave directions for the future conduct of the action. 23rd of June, insurers filed their defences. Again, these are available on the FCA website. You can read them. 26th of June, there was a further case management conference, which the court dealt with outstanding procedural matters. 3rd of July, the FCA is to file its reply to the defence of insurers. 10th of July, FCA and interveners, that will be the consumer groups. And I suspect actually now the brokers will be in there. They will have appointed a representative broker who will also be making submissions. That's got to be served by the 10th of July. 14th of July, defendants' skirts and arguments are served. And the 20th to the 23rd of July and the 27th to the 30th of July, there's going to be an 8-day court hearing before Lord Justice Flo and Mr. Justice Butcher. Certainly in respect of Mr. Lord Justice Flo, he practiced as a barrister, Julian Flo, and I had the privilege of instructing him. He then was, before he became a judge, was one of the go-to barristers for insurance disputes. He really, really knows his insurance. He knows how the market works. And I haven't come across Mr. Justice Butcher, but I suspect he will have been appointed as well because he has an in-depth knowledge of the insurance market. So you've got good judges here who will be analysing the case. From a legal perspective, it's not only interesting because it's the first case of this type ever, obviously on unique facts, but also it'll be the first case that I'm aware of which has been heard under the new Insurance Act of 2015, which was designed, which replaced the tried and tested Marine Insurance Act of 1906.
Yes.
But the Insurance Act of 2015 was designed to make it harder for insurers to avoid payment of claims. Now, not in all circumstances. There are certain things which it didn't alter at all. So, for example, late notification, the rule under the Marine Insurance Act with regard to that, and the new Act is more or less the same. You've got to notify your insurer at the first available opportunity. Hence why in my previous seminars and 10-minute talks that you and I have done together, Julie, I've been at pains to stress that you must notify your insurers. Even if they've now come back and rejected your claim, that's fine. You say, I don't accept your rejection. I'm going to wait for the outcome of the FCA case. Because, excuse me, it's extremely likely that if one of these insurers in this test case, it is found that there is cover, they will have to reverse their rejection of your claim and start paying it.
Ouch.
So, you know, this is a very important case, and we should have some early indications from the court, I would have thought mid-August, about which way they're going to go. but there is the right in the agreed documentation between insurers and the FCA for both parties to appeal. So final clarity, I can't see it again still much before the end of September. But I would recommend all who listen to this to go onto the FCA website. This is very transparent, and I applaud the FCA for doing this. It's an extremely good section on their website. It's clear, it's understandable, all the pleadings and documents are there. And by all means, have a read. But as I said, I still don't think it'll be much before end of September before we have some actual final clarity in relation to this. So that was it, Julie. That was all I was going to say.
Okay.
As I said, the case starts, fisticuffs commence on the 20th of July.
Excellent. I look forward to more updates and the final outcome when we get that. It'll be I think that could be a very interesting one.
Yeah, I'll certainly give if there are any further developments before the case start, which I doubt, then I will update. But I suspect my first update will now not be until August, when we've had some preliminary indications as to how the court's been thinking.
Okay.
Thank you very much, Julie.
We look forward to that. Thanks for your time as always, John. Thank you.
You're very welcome, Julie. Take care.
Take care.